Question: what if there was a reclassification of the area where your land is situated? At present, your land could be within the timberland or forestland area, but 30 years prior, it was classified as alienable and disposable. What will happen to your land certificate of title? So, nako example ani na a certain specific situation ba, so that we can provide an opinion. I can relay to you the opinion of the court on how it resolved this issue. There is this case where there was a reclassification 30 years later over a certain area. Your land, at the time the title was issued, your lot was within an alienable and disposable classification. 30 years later, the land within the 30 years later, the land was already within the forest land classification because there was a reclassification that occurred. So it is important to defend your certificate of title's validity because at the time of its issuance, the land was classified as alienable and disposable. The reclassification of the area where the property is located should not prejudice the land title of the landowner. Meaning, during the time that you applied for a land title and a decree was issued and a certificate of title was issued, let's say 30 years prior, your land was classified as alienable and disposable, and a certificate of title was issued. Even if that land, your land within that area, was reclassified 30 years later, already, let's say the reclassification was forest land or as timberland, so your area is already within the zone that classifies that area, the parcels of land within that area, as inalienable public lands. So what will happen to your title? So your title should remain valid if at the time of its application, grant, and issuance, the area was classified as alienable and disposable. Even if there was a subsequent reclassification, the area was later reclassified to be an area that is not alienable and disposable, it should not prejudice your land title. That is what happened in a certain specific case, but always be careful because the application of these rules and doctrine should be very specific on the factual premise or the factual structure of the case. A case, although it seems to be similar, there is a land title, the government made the move to have this land title cancelled, but the nitty-gritty of the case, its facts, are very important. You must appreciate these things in order to apply properly the law that should also govern these type of situations. Thank you.